Doug's going to fill in another piece of the puzzle.
Thank you, Douglas King.
Well, good evening, everybody. I want to thank everyone for coming tonight. I think this is probably one of the most important topics that exists in our society at large, and specifically here in the downtown east side in Vancouver. So as Donald said, my name is Doug King. I am a lawyer for the Pivot Legal Society and the litigation director, and I was one of the lucky people, I guess, to have the opportunity to work on a constitutional challenge to fight the federal government, former federal government Conservative Party, in their actions to try to shut down the Crosstown Clinic and the continued heroin assisted treatment program. In that regard, I want to make note, I guess, that I am one of a legal team that worked on the project that I want to talk to you about. Specifically, I want to point out the lawyers Joe Arve, Allison Latimer, Angela Juba, Scott Bernstein, and Adrian Smith. We're all very active participants and did a lot of effort in engaging in the kind of litigation, and probably most importantly, our clients that we represented, individuals who were part of the Salome Project, part of the SNAP Patients Association, and who really were the ones that pushed from the very beginning for a long-term continued heroin assisted treatment program after the clinical trial was done. If it weren't for their continued advocacy, then none of us would be talking here tonight. So I want to fill in a little bit of the story on that very last point that Susan talked about, which is the movement from the Salome clinical trial to what we now currently have in Vancouver, which is a permanent, hopefully, program where people are able to receive heroin in a clinical model through the Crosstown Clinic. And there was a transition that occurred, and I'm going to talk to you a little bit about the legal challenge in the case around the ideological fight that we had with the federal government, which prevented that from happening. So in 2013, when the Salome Project was ending, the clinical trials were ending, the doctors at Crosstown Clinic submitted what's called SAPs to the federal government, and that's a special access program. This program is designed to allow physicians to have special access to a drug that's not normally available. Not surprisingly, because of the history of prohibition, heroin was not a drug that was normally available. The exact same day that the doctors made applications, which were actually approved by Health Canada, to the special access program, the federal Conservative government stepped in to shut down the operation. And what they did was they introduced what's called legal regulations, and these regulations effectively said that no doctor will ever have access to heroin under the special access program. It was kind of a gut-wrenching moment, I guess, to get to the point where we were able to, continually advocate for a permanent heroin-assisted treatment program, to have Providence Health step in to make that a possibility and make it a reality, only to have the federal government at the last moment step in and say, on ideological grounds, essentially, we're not going to let this happen. So immediately, we formed, I guess, the best alliance that we could to try to fight this, and we brought what's called a constitutional challenge in the BC Supreme Court to overturn those federal regulations and to open up the ability for patients to access heroin-assisted treatment once again. And I'm going to tell you a little bit about that case. I'm going to try to make it as interesting as possible, understanding that constitutional legal questions are not exactly the most thrilling topic of the evening. But there are some very, very important and interesting aspects of the case, because at the heart of it, this case was about a clinical model, a scientifically backed, evidence-based procedure and treatment option up against what really has been an ideological fight in our country and many countries like it for the last 50 or 60 years. And there's probably nothing more telling than the federal government's statement when they introduced these regulations. While they ultimately went into court and argued that it was for the purposes of public safety, which is pretty much always the justification for drug laws in countries like Canada, in their actual media statement, the federal government and the health minister, Rona Ambrose, actually stated that their purpose was to take heroin out of people's hands to make sure that it wouldn't be put into their arms. And it was all about that idea of prohibition and the moral fiber argument that's continually battled with the Conservative government. So what we did when we started our constitutional challenge is we brought together, I think, a very, very important alliance, which up to this point hadn't necessarily existed in this form. And the alliance was that the Providence Healthcare, the actual clinical, medical setting, teamed up with the patients themselves. We represented 5 Salome participants who wanted to continually access their treatment. And we joined up together. We represented the patients. Providence represented, obviously, their program itself. And as a team, we argued that the federal government was unconstitutionally bringing these regulations. And we did so on 3 separate grounds. The first was that by introducing these regulations, the federal government was putting the security of our patient's person at risk. And this is Section 7 of the Canadian Charter of Rights and Freedom. It's the charter right that ensures that the government should not take away our right to life, liberty, and security of the person. It's probably the most important and sacred charter right that we have. We also argued that what the federal government really was doing was trying to regulate healthcare, and that they didn't have the authority to regulate healthcare, and that because of that, they were outside of their boundaries. And we also made an argument that under Section 15 of the charter, they were discriminating against our clients because the only reason they were treating them this way is because they were addicted to a substance, which obviously in the medical world is seen as a disability, and a disability is something that's protected under the charter. So one of the common misconceptions, I guess, that exists in the law is that you can't just stroll into the courtroom and ask for an injunction. You actually have to start a lawsuit first, and then through the lawsuit make an application for an injunction. So one of the toughest parts about this case was actually building the foundation for a lawsuit that would endure not just through the injunction stage, but ultimately something that we could argue 2 or 3 years down the line and try to get a final judgment to say that the government was clearly unconstitutional. And while we were waiting for that lawsuit to occur, we filed an application for that injunction, and we were able to have that injunction heard in March. Now, the funny thing about a case like this is in the legal community, all of this happened in about 6 months' time. The lawsuit was filed in November of 2013. We were able to receive an injunction against the federal government, which effectively stopped those regulations in March of 2014. In the legal world, 6-month turnaround on an injunction is actually pretty quick, and took a lot of effort and quick resourcing, obviously, and as you'll hear later on tonight, for the patients who are actually involved, 6 months is essentially an eternity. So it's a reminder, I guess, for us in the legal profession that as much as we can fight for these kind of rights for people, the rights in the courtroom can have an incredible toll in just how long it takes to actualize those rights and how to realize those rights. So in our injunction application, we most of all were fighting for the concept that these regulations were going to cause our clients irreparable harm. It's one of the tests for obtaining an objection. And one thing that you have to remember is at the time, in 2013, the crisis that currently exists in Vancouver was barely being talked about. In fact, it was only really starting to scratch the surface in the mainstream media. You started hearing stories about people overdosing. You started hearing kind of rumblings of something different that was happening. But at that time, it was not even closely widely accepted that we had a crisis about to occur on our streets. And that made it incredibly difficult to convince a judge that by taking away our clients' access to heroin-assisted treatment, that they were going to suffer irreparable harm. You know, in retrospect, looking back, it seems like an incredibly obvious argument to make. You had a group of people who had access to a clean drug supply in a clinical setting. Once they lost that, they would go back to using on the streets, and everybody knows now just how dangerous that is. But at the time, it took some very, very brave, some very, very detailed testimony from our clients to convince the judge. And, you know, for lawyers, we can argue the law, but they often say in law school that cases are won on the facts, and you have to have strong facts to win those cases. Well, our facts came from our clients, from the participants of Salome, and for the individuals who have operated in SNAP. And they really were able to clearly tell the judge just specifically what kind of a harm taking away heroin-assisted treatment would have. So one of the things that we're going to talk about tonight is, you know, what happens now? What happens in the future? Well, after the injunction was given, we had to continually fight the litigation, and we actually assumed that last year we would be going to trial and fighting the federal government on this issue in the hopes that we would get a strong judgment that said specifically that the government could not do this. What happened in between the injunction and the date set for trial was a change in government. And while there's certainly lots of criticism that could be leveled on our current government, one thing that they did was remove the regulations that were brought in by the conservative government and openly allowed for the continued use of heroin-assisted treatment in Vancouver. So by removing those regulations, they effectively ended the lawsuit, ended the constitutional challenge, and brought us back to the system that we had before. And I'm sure Dr. McDonald is going to give you much more detail about how Crosstown currently operates. and some of the difficulties that it continues to have inside the current regulatory system. But we were ultimately successful in obtaining the continued access to heroin treatment for our clients. In terms of where we go now, our office continues to say that the fight is not over. As much as Crosstown exists, we're continually left with this question of why there is only one Crosstown, and why is it only in one health authority. We're met primarily with silence from the other health authorities for why they haven't replicated the Crosstown model. And we still have concerns that if another organization, if another health authority, or even just an individual doctor tried to do what Crosstown has done and make an application to the federal government, there's no assurance that they wouldn't be shut down, that the federal government wouldn't deny that application, and then again, as a legal organization, we would be called in to step in and try to fight that. So certainly we have a lot of different kind of battles in the future that we anticipate we'll probably have to fight. And ultimately, it's going to come down, I think, to the medical community to continually push for the rights of their patients and to continually have to show the government why they're so necessary. So on that note, I wanted to turn it over to Dr. McDonald, who has probably the greatest knowledge in this area and can tell you all about Crosstown Clinic and how important it is.